Good afternoon, everyone. We are beginning this third plenary session on international law, human rights, and biodiversity. May I invite Ambassador Awood Marit Wiig, Ambassador of Norway in Brazil. I would also like to invite the two keynote speakers of this session, Dr. Parvez Hassan, Chair Emeritus of the World Commission on Environmental Law from Pakistan. He will be speaking on the role of the developing countries in the development of international environmental law, and Professor Jorge Vinuales, Harold Samuel Professor of Law and Environmental Policy at the University of Cambridge in the United Kingdom. He'll be speaking on the Rio Declaration after a quarter of a century. I don't need to say anything about the importance of this theme, but I would like to say one word about the chair of this session. As you know, and I said that last night, Norway is the most important environmental partner of Brazil. And perhaps, Mrs. Ambassador, I could say that Norway is the global partner, the most important partner of all tropical forests in the world. And it could come as a surprise that such a Nordic country, so distant from tropical forests, and your people have such a strong appreciation for the biodiversity, the foundations of life that those tropical forests hold. So when we invited you to chair this session, we wanted to pay a tribute to Norway and to its people, and to its people, to its institutions, to its government. So please, and I'm sure you do, in a telegram to your government, mention that we here, together in Rio de Janeiro, pay this very simple, very modest tribute to this work that Norway does. With that, I would suggest, if I may, after you say a few words, Mrs. Ambassador, that we invite Dr. Parvez Hassan to speak first, and then Professor Vinuales. But now, you are the chair, so thank you very much.
Well, thank you, Minister Benjamin, for those very kind words. It's indeed an honor to be present here at this conference, and I'm quite overwhelmed by the nice words you say about my country and my government. But let me also say that we have partnered with Brazil in the Amazon Fund, But the amazing results that Brazil has achieved in reducing the deforestation in the Amazon could not have been achieved without the political leadership in Brazil, without the public support, strict legislation, and not least empowered institutions and implementing agencies in Brazil. That is the reason that these results have been achieved, and the Norwegian contribution is after the fact. It's a results-based contribution based on the excellent achievements of Brazil. I think it's important to remember this, and that this is not development assistance in the traditional sense of the word. It is indeed an innovative instrument of contributing to the global climate, where we all have a responsibility. So with that introduction, I'm pleased to be able to chair this meeting and to give the floor to the first speaker.
Good afternoon, friends. I'm going to be speaking for the next 20 minutes on the role of the developing countries in the development of international environmental law. And the good news I have is that the developing countries have participated in the development of international environmental law, and international environmental law, and that's a submission I'm going to be making, is a truly universal international environmental law. Now, I've written a paper for this particular conference, and this may be available, but in the 20 minutes I have with you, I'll try to share with you the initial premise that attracted me to this topic and the conclusion that I have come out in the end. And I start this paper by suggesting that the title of this paper was inspired by two articles, one published in the American Journal of International Law in 1962, and the second in the International Comparative Law Quarterly in 1966 by my friend and my fellow student, R.P. Anand, at the Yale Law School in the early 1960s. His scholarship resonated globally to question the universality of public international law without the participation of Asian, African, Latin American, and other developing countries. He addressed these concerns in the background of the tumultuous period in human history when post-World War II, the global map was changing with the advent of numerous colonies in Asia and Africa as newly independent countries and as full and equal members of the international community in the United Nations. In 1962, Anand wrote a penetrating review of the European origins of public international law and how its norms had to meet the challenges of the newly independent Asian African states that had not participated in their adoption. He included the Latin American states that had similarly not participated in the development of the corpus of public international law at that time. To borrow his analysis, and I'll just give two quotes from him. He said that the present international law, mind you this is 1960s, the present international law was developed during the last 4 centuries and specially consolidated and systemized during the last part of the 19th and the beginning of the present century. Asian and African countries had very little to do with it because they were conquered and colonized and made to serve merely the interests of the metropolitan states and their masters. Therefore, though as a science international law can be traced back several centuries, it was only the 16th century which witnessed the birth of modern international law, and the Asian countries, in spite of their rich heritage, were unable to contribute anything to the development because of their subordinate positions. With respect to Latin American countries, Anand contended that moreover, and I quote, moreover, the protest against some rules of international law is not confined to Asian and African states. We find that even the Latin American countries, which have the same cultural, social, and religious heritage as the European countries, in other words, which are part of the same Western Christian civilization, have challenged the present system of international law in a number of places. Thus, we have seen earlier a statement by the Mexican member of the International Law Commission, the Calvo and the Drago doctrines that emerged from the Latin American countries are also challenges to the traditional international law, which is against the interest of the debtor states. Even today, we find some of these countries trying hard to change international law in order to make it more equitable. Now, so that is the premise from which I start looking at international environmental law and how it developed, and whether we international environmental lawyers will ever be handicapped by the same kind of allegations that were hurled against public international law in the 1960s. And really, to me, the most important things that happened as a prelude, as the curtain raiser to the development of international environmental law were two resolutions that were passed by the General Assembly. One in 1960, which was the decolonization resolution, and the second in 1962, the permanent sovereignty over natural wealth and resources resolution. Now, I've gone through the debates that led to the adoption of both these declarations, and I find that the language that today divides the globe in terms of the South mindset and the Northern mindset is all anchored in those debates. There's volumes and volumes of discussion about the acrimony, the bitter mistrust, the accusations of one against the other. And the socialist bloc, and this was the time when there was the Iron Curtain, and the socialist bloc joined the newly emergent Asian African states to really castigate and malign the development of international law as being European in origin, and so on and so forth. So in the United Nations Charter in 1945 and the Universal Declaration of Human Rights in 1948 had generated hopes and euphoria for a new international order anchored on the sovereign equality of states and the respect for the fundamental human rights and the dignity and worth of the human person. The newly independent members of the international community started clamoring for a voice and recognition, and the United Nations General Assembly became a natural forum for such efforts. The adoption of the decolonization resolution in 60 and the permanent sovereignty resolution in 62, both immensely facilitated by contemporary Cold War dynamics, was to imprint the future work and dialogue at all the fora of the United Nations. The decolonization, which came in 1960, proclaimed that all territories which have not yet attained independence, they must be transferred all powers to the people of those territories without any condition or reservation, in accordance with their freely expressed will and desire, without any distinction as to race, creed, or color. Importantly, it was recognized from the outset that political independence is inextricably tied to the right of each nation to its natural wealth and resources, and that's where environmental law comes in. It was important to express in unequivocal terms that people may, for their own ends, freely dispose of their natural wealth and resources without prejudice to any obligation arising out of international economic cooperation and based upon the principles of mutual benefit and international law. The permanent sovereignty resolution went further. And in 1962, this particular resolution considered that any measure must be based on the recognition of the inalienable right of all states to freely dispose of their natural wealth and resources in accordance with their national interests and in respect for the economic independence of states. And it declared that the right of people and nations to permanent sovereignty over national wealth and resources must be exercised in the interest of their national development and for the well-being of their own people. Now, it is against this particular background that we now get to Stockholm in 1972, the catalytic time when the entire progress with respect to environment, sustainable development, and environment international law was rooted at that particular time. And at Stockholm, and now start emerging some principles that develop into international environmental law. And in Stockholm, I'll just mention 4 principles that emerged there. 1, that the importance of development was recognized. 2, that the concept of environment being a sacred trust to be appropriately used for present and future generations was importantly highlighted. 3, equity was sought in the international economic system, and the need for international cooperation to raise resources to assist the developing countries was also emphasized. And 4, perhaps the most important principle that emerged at Stockholm was Principle 21, which declared the sovereign right of all states to exploit their own resources pursuant to their own environmental policies. Now, what really I need to draw your attention to is Stockholm was the first international conference on the environment and the emerging principles of the nascent international environmental law. It is remarkable also for the wide participation of the newly independent Asian African states that got a chance from the very beginning to shape the principles that would develop international environmental law. In fact, the representation from the South was impressive in the leadership provided to the conference. Prime Minister Indira Gandhi of India, for example, captured international attention as the most important face for the South, and she spoke eloquently for Asia, Africa, and the Latin American countries. So you see on the ground floor, you see the developing countries getting in. And the next important development in international environmental law was a World Charter for Nature, again seeded with a Southern imprint. It's not generally known that the World Charter of Nature was sown in the South. It was to be found in the inaugural address of General Mobutu, President of Zaire, who addressed the 12th General Assembly of IUCN in Kinshasa. The time is September 75, and Mobutu held out both a challenge and an offer, and I quote, "The seas, the oceans, and the upper atmosphere belong to the human community." And this is 1975, and this is not Anglo-Saxon, it's coming out of Africa. "One cannot freely overuse international resources. People of goodwill are looking to you for positive results from this assembly. That is why, if I had any advice for you, I'd suggest the establishment of a charter for nature. Insofar as Zaire is concerned, we are ready to help you succeed. If we are asked to be a pilgrim of environmental protection, this we would be willing to be." And that's President Mobutu. IUCN took up the challenge through its Commission on Environmental Law, which, using the UN Declaration of Human Rights as a model, developed the first draft of the World Charter. And then I next come to Rio. Rio came in with 4 or 5 principles, and that was one of the most magnificent assembly of humanity and its leadership that I was personally very privileged to be at. And I think it changed the world for all times to come, irrevocably. But it came out with some principles which again are being transformed into international environmental law. Acknowledgement of the interdependence of environment and development, that's principle 1. Recognition of the needs of both present and future generations. The establishment of poverty alleviation as an indispensable instrument for sustainable development. The agreement that the special needs of developing countries shall be given priority, and recognition for an equitable international economic system. The access to justice in principle 10, and the precautionary principle in principle 13. So you see the beginning of the development of international environmental law. In a way, Rio 1992 was a triumph for the imprint of the South on the global environmental agenda. India, through its Prime Minister Indira Gandhi, had lent much visibility to the South at Stockholm in 1972, Rio 1992 provided an excellent opportunity for Pakistan's stellar leadership as the chair of the Group of 77 to lead the South in Rio. Ambassador Tommy Koh from Singapore emerged as an important global leader on sustainable development. The emergence of these soft law, environmental law principles at Stockholm, the World Charter for Nature and Rio provided the foundation for a new global convention. The IUCN Commission on Environmental Law has for several years been engaged in the elaboration of a blueprint for a global convention and prepared several drafts of a proposed framework treaty on environment and development. We've been continuing this effort for the years, and we've just come out with the 5th edition. We met in Spain last year, and it's a very comprehensive global draft treaty. It has about 83 articles. It has articles on Declaration of Fundamental Principles, rights and duties of state, training, education, provisions on precautionary principle, and anything you can think of. But the point I wanted to make was, again, the southern orientation that's now coming in, and the imprint coming in. The experience in the drafting of the covenant was no different than the north-south divide in our other international fora. I led the effort in the last 5 years of the IUCN Draft Covenant to its launch in 1995 before the General Assembly in the UN. The contribution of this southern leadership was reflected in, one, the enlargement of the drafting group to include an effective representation of members from the South; two, the introduction in the covenant of issues of waste trade, the need to regulate the activities of transnational economic entities, and the strengthening of the clauses on the transfer of resources and technology as some examples of the reorientation of our work to the concerns of the developing countries. And I must confess that when I proposed and the working group accepted to anchor the covenant on fundamental principles, which is part 2 of a draft covenant, I did so because of my familiarity and experiences with fundamental rights in the constitutions of India, Pakistan, Sri Lanka, and Bangladesh. The Earth Charter is another important soft law document that has influenced the development of international environmental law. I was privileged again to have been associated with its drafting and to join Maurice Strong, Mikhail Gorbachev, and Steve Rockefeller in its launch at The Hague in 2000. And the Earth Charter's principles on respect and care for the community of life, ecological integrity, social and economic justice, democracy, nonviolence, and peace have also become the areas from which we pick up principles of international environmental law.